Hello everyone, everywhere on this beautiful planet called the Earth. Welcome to the webinar on the quest for legal frontiers between airspace and outer space. My name is Jakhu. I'm an associate professor and acting director at the Institute of Air and Space Law at McGill University here in Montreal, Canada. First of all, I would like to make a formal statement that recognizes the unique and enduring relationship that exists between the indigenous peoples and their traditional territories in Canada. And I quote, McGill University is located on land which has long served as a site of meeting and exchange amongst indigenous peoples, including the Hobe, and Haudenosaunee nations. McGill honors, recognizes, respects these nations as the traditional stewards of the lands and the water on which we meet today. Unquote. This statement befits very well with the rationale of this webinar, which is a meeting of people around the world. All of us are virtually meeting for the purpose of exchanging ideas on an important matter that relates to international legal regime for peaceful use of outer space and airspace. This second webinar is jointly organized by McGill Institute of Air and Space Law and the International Association for the Advancement of Space Safety. I will be calling the IAASS. About the Institute, since its creation in 1951, the Institute of Air and Space Law has been the world's leading institution in the fields of air and space law. Next year, the Institute will be celebrating 70 years of its rich history dedicated to excellence in graduate education, public service, and advanced scholarship. It has produced more than 1,200 graduates from more than 120 countries. During the last 15 years, the Institute has attracted grants and financial sponsorships worth millions of dollars for student fellowship, outreach activities, and research projects. The Institute's current multi-year major research project relates to the drafting of McGill Manual on international law applicable to military uses of outer space, in short, MILAMOS. While speaking of the McGill Institute, I recognize another institution which is at par with us, and that is the Cologne Institute of Air and Space Law and Cyber Law. And I am pleased to note my good friend, a colleague is joining us. He's a Dr. Stephan Hobe, who is the director of the Institute. The International Association for Advancement Space Safety, IAASS, was established in 2004 in the aftermath of the Shuttle Columbia accident by a group of safety engineers and managers. They were working on the International Space Station program and were from the United States, Europe, Russia, Japan, and Canada. They recognized some common problems with the shuttle program, as well as complications in the international setup of ISS program. Thus, they decided to give a voice to the international space safety community. McGill Institute and IAASS have long-standing cooperation in the field of space safety and space law. Over the past several years, both institutions have prepared studies on the topic of suborbital space flight and the delimitation of Space and Outer Space. As a permanent observer of the UN COPIUS, the IAASS has submitted the results of these studies to the legal subcommittee of UN COPIUS. Initially, the reports aimed to provide a status of debate between spatialists as opposed to functionalist approach. More recently, IAASS Policy and Legal Committee launched a study to develop draft provisions of a possible convention that would apply to intermediate region between airspace and outer space, tentatively called near space, lying between 18 kilometers and 160 kilometers. And I want to make it clear that the Institute of Air and Space Law has not provided any input in the drafting of the draft convention, but we have been invited to provide our input, and that is the purpose of this webinar, to seek the views of the experts and all the people attending the webinar. So we will be appreciating your comment, which help us and formulating our own views and revising this draft convention. Before I introduce the moderator of this webinar, I would like to acknowledge the significant contribution to the design of this webinar made by Mr. Tommaso Sgoba, who unfortunately is unable to join this event. Tommaso, who is the executive director of the IAASS, is the real brain behind this webinar. I have known Tommaso for the last 15 years. He's a highly competent space safety professional and is a wonderful person to work with. This webinar is going to be moderated by Dr. David Kendall. David served as the chair of the UN COPIUS. Previously, he was Director General of Space Science and Technology with the Canadian Space Agency. David has nearly 40 years of experience in the space sector. He has been a faculty member of the International Space University for over 2 decades. David is a founding member of Outer Space Institute at the University of British Columbia. Thank you very much for your attention. Over to you, David.
Many thanks, Ram, and welcome to everybody around the world. Good morning, good afternoon, good evening, and for some people, good night. So we are very much looking forward to the next couple of hours, where we will try and discuss in some detail and come hopefully to some ideas about this convention that has been forwarded and put together by the Institute for the Advancement of Space Safety, International Association, I should say, for the Advancement of Space Safety, sorry, that Dr. Jakhu mentioned. So the way we're going to work today is we're going to start off with a couple of discussion papers provided by 2 eminent people on some background to the convention, and then we will move to a distinguished panel of experts who I will introduce in a minute. And then, of course, we will open it up to discussion and hopefully some comments by you who are attending this particular webinar. I would like to ask all members or all people who are not speaking to please mute their microphones. It is very important that microphones be muted if you are not actually speaking on this webinar. A lot of background noise can really make a bit of a mess of these types of events. Secondly, once we get to the question time and after the presentations and the panel has been introduced, we would and some questions directly to the panelists. We would like to ask you to use the chat function on the Zoom platform. The chat platform is very useful If I have to, or if we have to select various people to speak, it tends to make it a little bit more difficult. And the chat platform, frankly, is a way to shorten some of the questions and to have a little bit more time for the interaction. One way that the chat platform can be very helpful is that if you see a question there that you support, you can use a thumbs up button and you can push it to the top. So the way we will work is that please submit your questions on the chat function, and then use your if you like something, then advance it, and we will then see which of the questions are obviously the most supported by those that are attending. So if you could please do that, it would be very very helpful. So again, the objective of the webinar is to collect comments from a selected number of experts on this draft convention. And then the second objective is clearly to introduce the draft convention to you, a wider audience who will have registered to attend, this webinar. And I should mention right away that there is a website, if you haven't already been there, where you can find all the background. It is basically www.mcgill.ca/IASL/space-law-webinar. Again, mcgill.ca/IASL/space-law-webinar. And there you will can see the draft convention and some of the background that we'll be talking about. And we are intending to put on that particular website a way for you to send comments afterwards. If you have if your question didn't get answered, or if you would like to make comments, there should be a way to do that. And there will also be a Google form which will be sent to you directly if you've registered for those comments. We really would have the comments from you on this particular event. So background here, and that background is that the internet just had a bit of a hiccup. So I'll go back and say what I just said. This topic of the delimitation between airspace and outer space has been discussed, as most of you know, for many years within the legal subcommittee of COPIUS, and was first mooted and first discussed in COPIUS formally in 1967. So we're talking here of 53 years of discussion. I will quote from the conclusion of a document that was published in 2002, which summarized the first 35 years of discussions. And I quote, this is the conclusion from a document you can find on the United Nations website. Since the beginning of its consideration of the question of the definition and delimitation of outer space in 1967, the legal subcommittee has heard diverse views on the issue and considered and addressed numerous proposals received. No agreements on substantive legal issues relating to the definition and delimitation of outer space are apparent from the reports of the subcommittee or of the Committee on the Peaceful Uses of Outer Space. However, consensus has been reached on the referral of the issue to the Scientific and Technical Subcommittee for consideration, the preparation and updating of background papers on the question, the establishment of a working group to consider the issue on a priority basis, this was in 2002, the consideration of issues relating to aerospace objects, the finalization of a questionnaire on possible legal issues with regard to aerospace objects, the preparation of a comprehensive analysis of the replies received to the questionnaire, that the questionnaire could serve as a basis for future consideration of the subject, and on the preparation of the present historical summary on the question of the definition and delimitation of outer space. I would say that that statement could be fast forwarded to 2020. there has been effectively no further agreements on this question within COPIUS. And every year the working group meets, and every year one has a number of states which state that, yes, this is an urgent matter, and a number of other states which say, not really, this is a matter which we have dealt with over the past 60 years, and there's no need to now to rock the boat, so to speak, and to actually find a solution to this issue. Now, the International Association for the Advancement of Space Safety has, I think, very wisely decided that maybe now is the time to move this issue forward a little bit more rapidly. So it is, as Ram said, this convention that is now being discussed will be forwarded and discussed, will be forwarded for discussion at the legal subcommittee. Unfortunately, it did not meet due to the coronavirus pandemic this year, and the plan is to meet and to put this forward by the IAASS next year, hopefully next April, at the legal subcommittee of UN COPIUS. So the question may arise as to why is now a good time to move this issue forward, given that there have been so many years, so 53 years of really no agreement. And I will quote from Tommaso Scoba, who unfortunately cannot join us today, who is the executive director of the International Association. And here is Thomas's quote as to why there is some, the IAASS believes that there is some urgency here. There is notoriously a deficit of international safety governance in space missions. The hazards created by space missions are of international nature, in the sense that they are created by space actors internationally and can be effectively controlled only through international cooperation. However, for the operations between the upper limit of controlled airspace and the lower reaches of Earth orbits, there is, in addition, a legal deficit due to the undefined border between airspace and outer space. The projected exponential increase of traffic through the region due to the operations of mega constellations and the interest for novel commercial and military exploitation by high altitude platforms make necessary to urgently define a legal regime for near space that can make it safe, sustainable, and commercially viable. Just to make it more clear, when a country launches a rocket, usually spaceports are close to the sea, and in a matter of a few seconds, the rocket will be flying through the international airspace that begins 12 miles off the coastline, and then overflying foreign territories before achieving orbit. The risk along the rocket trajectory is mainly on foreign populations. It is the same story at re-entry from space. At the end of a mission in low Earth orbit, it costs fuel to make controlled re-entry that would place a satellite in a precise and safe spot on the Earth's surface. But operators prefer to spend that fuel on orbit to generate revenue. Therefore, most spacecraft and spent rocket upper stages are left to slowly re-enter the atmosphere following a so-called natural descent due to the tiny friction generated by the residual atmosphere. When the spacecraft is low enough to be in contact with the denser layers of the upper atmosphere, it would randomly bounce and skip until it sinks, fragmenting and sometimes exploding. Most fragments just evaporate because of the intense heat of re-entry, with pollution effects still to be understood, but many survive and hit the Earth's surface on a several 100-mile long ground track. Many debris end up in the oceans and some hit the ground. Small debris may be of no consequence if hitting a building, but are potentially catastrophic if colliding with an airliner at cruising speed. Nowadays, uncontrolled re-entries happen every week. In the near future, with the deployment of large satellite constellations, uncontrolled re-entries may become a daily occurrence. So this is a quote from Tommaso Scoba, and really tries to put into context the reason why there is some urgency in trying to see if we internationally can come up with an idea or some new ideas, let's put it that way, that can break the deadlock currently that is within UN COPIUS as to how to define and delimit airspace and outer space. So with that, I will move on to introduce the various speakers, and I will start with the panelists. We have 5 very distinguished panelists for today. They are Professor Stephen Freeland, Professor Stephan Hobe, Professor Timiebi, Aganaba Gianti, Professor Liu Hao, and as well Professor Ram Jakhu, who will be the last speaker on the panel. I will give their short biographies just before the panel starts, and before I introduce each of them during the panel session. But before then, we will now move to 2 discussion papers. One by Maria Manoli and another by Mini Gupta. And I will introduce both Maria and Mini. So the first paper on functionalist, spatialist, and intermediate region approaches by Maria Manoli. Maria is currently completing her doctoral degree in Air and Space Law at the Institute of Air and Space Law of the McGill Faculty of Law, where she has also been an Erin J.C. Arsenault Doctoral Fellow in Space Governance. Her research interests include public international law, space law, legal theory, and comparative legal methodologies. She is an attorney at law registered with the Athens Bar Association. And I will now pass over to Maria for her presentation and for her discussion paper. Thank you, Maria.
Well, thank you very much for the introduction. Let me share my screen. So hello everybody, I am Maria Manoli. I am a doctoral candidate at the Institute of Air and Space Law at the Faculty of Law of McGill. And before I start my presentation, I would like to thank the Institute of Air and Space Law at McGill and the International Association for the Advancement of Space Safety, and particularly Professor Jakhu and Tommaso Scoba for the invitation to participate in this webinar. So I have been asked to present the first paper that will be discussed today, which covers some of the approaches that have been proposed in the context of airspace and outer space delimitation and the applicable legal regime to aerospace activities and vehicles. And I will be specifically focusing on the functionalist and spatialist approaches, which are the 2 main approaches so far, as well as on the proposed intermediate region and near space approach, on which Mini Gupta will elaborate further in the second paper that will be presented today. So my presentation will serve mostly as an introductory background to the general theme of today's discussion. The paper that I am presenting is in fact based on a submission of the Space Safety Law and Regulation Committee of the International Association for the Advancement of Space Safety to the Legal Subcommittee of the United Nations Office of Outer Space Affairs, which was co-authored by Professor Paul Dempsey and myself in 2017, and which was later published again by Professor Paul Dempsey and myself as an academic article in the Annals of Air and Space Law. Excuse me, I have to stop. Can you still see my screen? Yeah? All right. So my presentation is divided into 4 parts. First, I will present the context of this topic and the main questions that arise. Second, I will speak about the first main approach that has been proposed so far, which is the functionalist approach, and some issues that are related to this approach. such as the definition of aircraft, space objects, and aerospace vehicles. And I will also speak about some of the problems that are associated with this approach. Third, I will move on to the second main approach, the spatialist approach, and I will also talk about some of the problematic aspects of it. And finally, I will make a brief introduction to the near space and intermediate region approach that will be discussed in detail by me. So the need to question and clarify the definition of airspace and outer space and the applicable legal regimes of airspace and airspace vehicles is a consequence of the growth mainly of commercial activities, of the new technological opportunities, and of the emergence of advanced transportation and new space activities that use both airspace and outer space. At the same time, the increase in air traffic and space traffic poses high risks of collision, especially in the phase of re-entry of vehicles, which is something that renders the need for a unified air and space approach essential. In terms of the existing legal regime, the 5 UN space treaties were created before commercial activity in space became as dominant as it is now. And at the same time, it remains unclear whether space vehicles could be governed by air law, especially when they operate in outer space. Moreover, the delimitation between airspace and outer space is an issue that still remains unsettled, and it therefore complicates the discussion even more. The issue has been addressed through several approaches. The 2 main approaches are the functionalist approach, which is based on the function and the purpose of the object, and the second main approach is the spatialist approach, which is based on the space, the location where the object exists. The existing legal regime, namely the Chicago Convention and the 5 UN space treaties, entail elements of both. Specifically, the Chicago Convention is applicable to airspace and to aircraft, while the Outer Space Treaty is applicable to outer space and to space objects. However, neither of these instruments define these legal terms. As a result, one more element which highlights the importance of this issue is the legal uncertainty that is caused and the potential conflicts that can be caused between the 2 regimes, air law and space law. The main difference between the 2 regimes is the fact that air law, the Chicago Convention, is based on the complete and exclusive sovereignty of states over the air above their territory, while space law is based on the lack of state sovereignty in outer space. The first approach, so the functionalist approach, tackles the issue based on the function of the vehicle by taking into account its purpose, its activity, and its destination. For example, whether the primary purpose of a vehicle is to go into outer space or to conduct space activities is one of the main questions to be asked based on this approach. Similarly, the technological characteristics of the vehicle, its design, its aerodynamics are also taken into consideration. If, for example, the vehicle is capable of acquiring lift through the air, it might be thought to be an aircraft. Now, 3 questions are directly linked with the functionalist approach. First, what is the definition of aircraft? Second, what is the definition of a spacecraft and a space object? And third, and most importantly, what is it that makes an aerospace vehicle? Let's start with the aircraft. The term is not defined in the Chicago Convention. One of the first definitions that describes aircraft says that aircraft is a machine which can derive support from the atmosphere from reactions of the air. The Paris Convention of 1919 defines aircraft as a machine which can derive support in the atmosphere from reactions of the air as well. And ICAO defines aircraft only in 1967 in Annex 7 of the Chicago Convention, where aircraft is described as any machine that can derive support in the atmosphere from the reactions of the air other than the reactions of the air against the surface of the Earth. which is something that makes clear that higher altitudes where support cannot be provided by the reactions of the air would be excluded from the definition. Now, based on this definition, ICAO could consider an airspace vehicle launched by a rocket as an aircraft during the descent phase when it is using its wings to land, but not during the phase of ascent. Relatedly, in 2005, ICAO noted that if suborbital vehicles are considered primarily as aircraft, the rules of the Chicago Convention would apply, with emphasis on registration, airworthiness certification, pilot licensing, and operational requirements. Space object, similarly, neither the Outer Space Treaty nor the other 4 UN space treaties define the term space object, but as opposed to the definition of aircraft, it could be thought that spacecraft is a vehicle capable of moving in outer space, orbital or suborbital, without any support from the air. So to classify a vehicle as either aircraft or spacecraft, the functionalists would ask whether the functions of a vehicle resemble those of an aircraft or spacecraft, and whether the purpose that it fulfills is inherent to aviation activities. For functionalists, for example, suborbital flights for space tourism would be classified as aviation activities, and therefore the vehicle used as aircraft, whereas the case of stratospheric balloons would not be as straightforward. So what would happen in the case of a hybrid vehicle capable of both flying and traveling in outer space? Would the hybrid nature of the vehicle mean a hybrid legal regime too, and the involvement of both air and space law? The International Association for the Advancement of Space Safety defines suborbital flights as flights up to an altitude at which the vehicle does not reach orbital velocity, and relatedly, a suborbital vehicle as any vehicle conducting suborbital flights. Now, the problem with the functionalist approach is focused on suborbital flights. For example, an Earth-to-Earth suborbital transportation flight would be considered as subject to air law, as it only briefly passes through outer space. And similarly, the vehicle of an Earth-to-space launch would be considered under space law because it mostly operates in outer space. Accordingly, the danger that arises lies in the fact that these vehicles use a part of airspace which is simultaneously used by aircraft. And as a result, the implementation of 2 different legal regimes, air law and space law, for the use of the same space would pose serious risks of collision and conflicts. Therefore, the need for unification and harmonization between these 2 regimes seems to be the most appropriate solution. The US federal law defines suborbital flights as any flight of a launch vehicle, rocket, or missile that does not achieve orbital insertion. This is to be noted before I move on to the next approach, which is the spatialist approach. And this is one more way of determining what law applies by asking where the object is. However, due to the lack of delimitation between airspace and outer space, the determination of the applicable law based on the location seems to be a challenging task. For this reason, the spatialist theory suggests the establishment of a specific delimitation between airspace and outer space, and the suggested such delimitation is the 100 kilometers altitude, the so-called von Karman line, where the air becomes so thin that aerodynamic control of the rocket is no longer possible. The first major problem with this approach is that there is no consensus about the delimitation line between airspace and outer space. This also means that we do not know where state sovereignty ends, and this is because, contrary to the Chicago Convention, which establishes complete and exclusive sovereignty in the airspace above the territory of states, the Outer Space Treaty and generally space law denies sovereignty of any kind in outer space. And neither the Chicago Convention nor the predecessor Paris Convention of 1919 provide the limit of airspace, and as a result, they do not provide the limit of territorial claims. Now, the von Karman line is suggested as a possible demarcation point because most of suborbital flights can can reach approximately this altitude. The spatialist approach appears problematic, however, for one more reason. Even if this altitude or another altitude is accepted as a demarcation line, it is unclear which legal regime would be applicable, as it would be difficult to determine on which side of the demarcation line the event would take place in case of events that take place near or on the demarcation point. So due to the legal uncertainties and all these safety risks that are posed by the two main currently existing approaches, an approach towards a unified legal regime is suggested as a solution able to provide certainty and to mitigate the risks. Furthermore, the absence of uniformity of law and the presence of conflicting and overlapping laws would impair the market's interest in investment in space transportation and the insurance industry's ability to assess and price the risk. As a result, the industry of suborbital flights would greatly benefit from such a delineation and demarcation between the two spaces and consequently the two regimes. To enforce this, the concept of a near space and the intermediate region has been proposed, introducing a zone starting at 20 kilometers or 18 kilometers, which is the upper limit of civil aviation traffic, and extending up to 160 kilometers, which is the lowest practical operating orbit for satellites. This is space between airspace and outer space, and the establishment of such a zone, such a region, would set as a result both the upper limit of airspace as well as the lower limit of outer space. This zone would cover emerging space activities that use these altitudes, including activities of suborbital vehicles, stratospheric balloons, pseudo-satellites, and high-altitude drones, all of which pose risks to air traffic beneath and to the public on the ground in case of failures or malfunctions. One alternative altitude to this approach is to define the lowest altitude at 50 kilometers, which is the upper limit for stratospheric balloons, and the highest at 120 kilometers, which is the re-entry threshold for a space system. So this region, the intermediate region, would be treated legally as a separate region as per the approach that is taken in the United Nations Convention on the Law of the Sea, and specifically as far as the legal treatment of territorial waters and the high seas is concerned. And specifically, this approach would suggest the following regions: the outer space zone, without any kind of sovereignty, where space law would be applicable; the near space zone or intermediate region, a zone open to innocent passage with aerial safety zones and with region-specific navigation rules; and the airspace zone, the zone below 50 kilometers, with exclusive sovereignty of the underlying state, where air law would be applicable. And finally, what are the advantages of this unified and harmonization approach? First and foremost, we would have an indirect definition and delimitation of outer space and airspace. Also, the clarification of the applicable legal regime would provide legal certainty. Legal certainty not only in terms of the regime applicable to the intermediate region, but also in terms of applicability of air law and space law to the areas below and above the intermediate region. Finally, there would be a better chance of coordination in terms of management of various issues such as safety, strategic security, traffic control, stratospheric pollution, frequency interferences, and other technical issues. So this was an overview of the currently existing approaches to the issue of definition and delimitation between airspace and outer space, and a short introduction to the proposed intermediate region approach, about which Mini will be elaborating in more detail by presenting the draft Near Space Convention. Thank you very much.
Thank you very much, Maria. I just would like to read out one statement from Joseph Pelton, who was quoted in the presentation by Maria. Joe, who is a the chair of the International Academic Committee of the International Association for the Advancement of Space Safety, sent us a quick statement, and I will read it because he has suggested an area which he calls the proto-space, which is very much along the lines of the presentation that Maria mentioned. So he has suggested that the 12 nautical mile zone of territorial waters, as suggested by, or as noted by Maria, might be equated to a 20-kilometer ceiling for airspace, and the exclusive economic zone of 200 nautical miles that is part of the law of the sea might be equated to 160 kilometers as a start to outer space where satellites can be sustained in orbit for a long time. And he says the protozone in between would be subject to national control, but that activities like high altitude platform systems could be licensed to commercial organizations or countries under internationally agreed terms and conditions. So very much supporting what Maria has said just now, and but where this so-called protozone or intermediate zone actually starts and stops is going to be an interesting discussion, certainly in the future. Okay, so I'd like to now introduce Mini Gupta. Mini is an advanced master's candidate in air and space law at Leiden University. She has interned with the International Association for the Advancement of Space Safety, has been a practicing attorney at the Rajasthan High Court in Jaipur, India. She obtained her BA LLB honors in 2011 from the National Law School in Bangalore. And Mini will introduce to us the draft convention on near space intermediate regions. Mini, over to you, please.
Thank you, David, for the introduction. And hello, everyone. Thank you for joining us. I'm an advanced LLM candidate in Leiden University currently, and I interned with IASS on this project of developing the draft convention. And I'll be presenting the findings of the IASS study draft convention on the regulation of near space. Just to repeat, in case somebody has joined late, you can access the introduction and the draft convention on the McGill University website. The presentation has been structured in 4 parts. I'll first introduce the IASS study draft convention and how it came about. I will then go over the essential key provisions of the draft convention in 3 parts. Part 1 will introduce the provisions of the draft, like the introductory provisions of the draft convention. Part 2 will deal with proposed rights of the underlying state. And part 3 will talk about the regulation of private activities in near space. There have actually been many proposals for an intermediate zone as a solution for delimitation of airspace and outer space. However, there is right now no consensus on what that legal regime should look like. So IASS has taken this step to take this idea a step further by drafting a draft convention, which is an attempt to encourage a more detailed discussion on what the legal parameters of near space should look like and to build more consensus. To understand that how this convention, to understand the basic dilemma of this convention, we need to visualize what the current legal scenario is. First, we have the national airspace, which is completely under the control of sovereign states. And compared to that, in contrast, we have the outer space, which is free for exploration and use by all states. So an intermediate region would try to balance the national interest and control requirements of airspace and the collective international interest that we see in outer space. To draft this convention, we first identified the legal challenges that a near space regime should address. And for then each of the challenges identified, we considered aviation law, outer space law, and law of the sea, as well as academic discussions to come up with possible solutions. Additionally, international trade agreements and national space legislations were required for drafting. Now, part 1 contains the introductory provisions, which establishes near space. Near space has been defined as a region above and adjacent to national airspace. Therefore, where national airspace ends, near space begins. The delimitation for IASS convention has been provided at 18 kilometers to 160 kilometers, which is open to discussion. However, our justification for 18 kilometers is, as Maria pointed out, flight level 600 and 18 kilometers are approximately the same altitude, and that's where most nations at present control their air traffic management. 160 kilometers, on the other hand, is the lowest perigee of a satellite in circular orbit. The horizontal boundaries of near space are open to debate, and there are two possibilities. Either the horizontal boundaries of near space can be made to coincide with national airspace boundaries, thus they will include the territory and territorial sea. That way, it gives an ease of management that near space extends like a column right above national airspace. However, there is also a possibility to include EEZ and contiguous zone in the boundaries of near space. The benefit of this approach would be to give greater economic power to the underlying state and also probably encourage more commercial activities. As an introductory provision, a spatial definition of aerospace objects has been provided in the draft convention. The draft convention states that aerospace objects are any objects that are designed to operate in near space. As Maria mentioned, a design-based definition of suborbital flights and high altitudinal platforms is leading to a lot of debate and confusion in legal circles. However, if we take a spatial definition, a lot of those problems would be addressed, and also a long-term solution would be provided, because emerging technologies can again be a challenge if we take a design-based approach. Secondly, suborbital flights have been defined in the draft convention as rocket-powered flights up to any altitude during which the vehicle does not reach orbital velocity. We have taken a focus on velocity rather than altitude because it is very easy to distinguish orbital flights from suborbital flights based on velocity. Many of the corpus discussions are focused on altitude, and there is at present no certainty because of that whether those activities are airspace activities or outer space activities. This definition, we hope, would create some clarity. The draft convention also clearly states that near space is separate from airspace, and therefore the legal regime of airspace does not apply to near space. It also clearly states that it is separate from outer space. So the outer space treaties don't apply to near space. By doing this, what we are trying to say and create is that near space is a separate region and a separate legal entity from airspace and outer space. Thus the convention would determine what laws and regulations should apply to near space rather than existing treaties. It is also stated that near space is not part of the territory of the underlying state. This is very similar to the exclusive economic zone concept and the law of the sea. And what this also does is that the laws of an underlying state do not automatically extend to near space. Given that background, the question comes, then what are the rights of underlying state in near space? So this is what part 2 is about. Underlying state under the draft convention has been given the right to use and administer near space to the exclusion of others. So this sort of gives the economic priority right to the underlying state. They get the first right, and then other countries can request their permission to join their near space activities. Underlying state can also permit placement of stationary or hovering objects in its near space. Further, although underlying state does not have any sovereignty over near space, but there will be aerospace activities that are taking place in its near space and might affect its security and safety. Therefore, the jurisdiction of underlying state has been extended to near space. Similar to the high seas regime under air law, where airspace which is not under any nation belongs to the high seas, and that is under the administration of ICAO. So similarly, near space over high seas has also been recommended to stay under the administration of ICAO. Also, as an exception, innocent passage of civil or commercial activities is freely allowed in near space if the safety standards are met according to the underlying state. Part 3 provides what should be the parameters of private activities in near space. Underlying state has been given the power to control private activities in near space, and some governing principles have been provided which should dictate what kind of legislations should be provided by the underlying state. There should be near feasible universal access. That means as little discrimination between the activities of various countries, highest degree of safety and security, uniformity of standards, and international cooperation. Ideally, an underlying state will control aerospace objects registered in the state, or activities that are performed by operators with principal place of business in the state or permanent residence in the state. Further, underlying state is also to provide rules for foreign operators, for example, prior notifications, approval, and duration of deployment in its near space. Terms of operation are to be decided before the object is deployed. This provision has been specifically provided to give more legal certainty. If terms of operation are decided before objects are launched, there is much more clarity about liability regimes. And lastly, absolute liability of operator for damage to the uninvolved public has been provided for. There's also a miscellaneous section in the draft convention which deals with issues like environmental pollution and traffic management of near space that can be referred to if required. I would like to end by saying that aerospace technology is developing at a much faster rate than law. A legal uncertainty affects businesses, and a proposal like the draft convention can be an important start of a discussion. Thank you.
Many thanks, Minnie. I think that last slide was very appropriate. We are moving very rapidly in commercial space right now, as everybody knows. Legal certainty is clearly an important part of investor confidence in the future of this very essential field. I would like quickly to welcome those that have joined us since the beginning of the webinar. Just to recap, we are discussing the quest for a legal frontier between airspace and outer space. We have just seen two discussion papers on the functionalist, spatialist, and intermediate region approaches by Maria Manoli. And now we've just heard from Minnie Gupta on this draft convention. For those of you that are interested, the draft convention is available through the McGill website, www.mcgill.ca/space-law-webinar. Just go there and you can see the current draft convention. Now, the other thing that I'd just like to mention, I see there's a number of questions that are starting to appear, which is excellent. And could you please use the chat function to provide us with your questions? I'm sure that those two presentations hopefully have generated a lot of ideas and questions, which is one of the reasons why we're meeting here today with this webinar, to try and get your feedback. And before I pass on to the distinguished panel, I would just like to mention that for those of you that are joining us here, we are being very well supported by Kiran Mohan Vazapulli, who's managing some of the chats here, who is on study leave and is the legal officer of the Asian African Legal Consultative Organization. And he is also an LLM thesis candidate and Erin J.C. Arsenault Graduate Fellow of the Institute of Air and Space Law at McGill University, and we're very fortunate to have Kiran supporting us in this endeavor. So now I will pass on to the panel, and I'll ask the panelists, please, just to give a very general overview of what they've heard so far, and a little bit of their thoughts of the issues that we're dealing with respect to both discussion papers, but especially, of course, the draft convention. Then we will move into some specific questions for each of the panelists, and after that, we will then open it up for panelists to respond to questions from you, the attendees and participants who have kindly joined us today. So I will start off by inviting Professor Stephan Freeland, who is the professor of Western Sydney University and specializes in commercial space law, which is, of course, very much an important element of what we're talking about here. Professor Freeland was previously the Dean of the School of Law at the Western Sydney University. He has been an advisor to the Australian, New Zealand, Norwegian, and several other governments on issues relating to national space legislative frameworks and policy. He has represented the Australian government at copious meetings where I had the pleasure of meeting him on several occasions. He has been appointed by Copious to co-chair discussions on the exploration, exploitation, and utilization of space resources at the forthcoming meeting that's next year of the Copious Legal Subcommittee. So, Stephan, your initial comments, please.
Thank you, David, and hello, everybody. It is 1 a.m. here in Sydney, so forgive me if I don't look my chirpy best. Let me begin firstly by acknowledging, as Professor Jakhu did, acknowledging and paying homage to the elders and the custodians of the land where I am and where everybody in the world is. Let me also thank both McGill University and IAASS for the kind invitation to speak. And let me also thank Maria and Minnie very much for your presentations. It's a very timely topic. I have a few thoughts, and I will probably play devil's advocate during the discussion, because my starting point is I'm not convinced that a designation of a separate legal area is in fact a feasible and appropriate solution, although I am very convinced that we clearly need to look at the legal framework that applies to various types of technologies that operate in that area. And I will give my reasons during the discussion. But let me start off by saying we're looking at different concepts and maybe conflating them a bit. The discussion started off with David very rightly pointing out that we've been looking at questions of the delimitation and definition of outer space and its differentiation, therefore, from airspace for forever, almost as long as I've been alive, so no, not quite as long as I've been alive. And as David says, you go to every COPOS meeting, you have 20, 30, 40 countries saying it's an urgent need, we need to do this, and indeed, some of them will actually give their assessment of where that demarcation might be. Nobody defines outer space, we just concentrate on the delimitation. But at the same COPOS meeting, you will then have traditionally the larger spacefaring nations saying, well, we've never had a demarcation, nothing has turned on it, things work well in space, why do we need it? We've covered the area. So that's the fundamental point, and we haven't got consensus there. The decision in the end, people say it will be driven by science, people say that it'll be driven by law, people say that it'll be driven by commerce. These decisions will be driven not by those, although they might be relevant, they will be driven by politics. And it's for the geopolitical reasons that we don't have that demarcation. So I stress that point because this concept, and I'll come back to it obviously, although it has many, many merits, is taking that far, far further. We're now proposing to states who are very, very careful to abrogate any of their perceptions of their sovereign rights. We're now saying to states, well, in the interests of moving forward, and I'm not saying it's a bad idea, I'm just saying that states will not accept the idea of, if you like, giving away more of their sovereign rights or their perception of sovereign rights to create this area. I say that as a general point, people may disagree, but David and others have seen the way that politics and the notion of clinging on to whatever sovereign rights may be applicable to the discussion, even though we recognize that sovereignty is not applicable to outer space. But sovereign rights are very much at the core. So I make that as a general statement. However, Minnie and Maria are absolutely right. We need to look very carefully at legal frameworks. And that's for two reasons. And these reasons are almost conflicting, but in fact, they both lead to the same conclusion. One reason is that the distinction in my mind between airspace and outer space is blurring. It's blurring because of some of the technologies we were talking here about suborbital flights, but other technologies which make it clear that aircraft are highly dependent on space technology. Spacecraft are highly dependent on things that may happen in this, if you like, below space area. Let's call it airspace for the present time. And indeed, there are lots of projects, NASA, for example, and others, but NASA is looking at a project to augment its satellite program in space with, if you like, high altitude platform pseudo-satellites to create an even stronger broadband network. So there's an interdependence, a growing interdependence from a technological viewpoint between what's happening in space and what's happening in airspace. Not in every thing we do in space, of course, but that distinction in one sense is blurring. The other reason, which in a sense sounds contrary to what I've just said, is that because of the development of technology, we are doing more and more and more discrete things in both space, but in this area that Minnie has termed near space. I won't call it near space in my own mind, but for the present purposes, in the area that Minnie has designated, the technology is allowing for many, many more things to happen. And we see pseudo-satellites, we see high-altitude drones, we see balloons going at an altitude that is clearly above flight level 600 that was referred to, clearly above what is typically the administrative of the Civil Aviation Authority of the relevant state. So clearly, there is this, if you'd like, grey zone of administration for these new technologies that look and smell and that don't look and smell and taste like spacecraft and space objects in space, but are beyond the traditional commercial airspace. And so it's quite clear we need to do something about that. And so how do we solve this? There are a number of things we can do. We can do nothing. But clearly, I think everybody on the panel and our speakers have very cogently argued that to do nothing is really kicking the can down the road, and there will be problems. We need to do something. We can do something that is proposed here. Create a new regime, a new area with a whole range of the geopolitical consequences that will give rise to, and then try to create something to fit into that regime. Recognizing, I think, that there are many issues, the detail in the draft convention we can talk about. There are many issues of detail that need to be addressed. Or there is a middle ground. And the middle ground is around not creating a new area, but creating new law, and appropriate and applicable law. And that can be done in two ways, and it should be done in two ways. It should be done through a recognition that we need to coordinate much more a legal framework about what happens in air, traditional airspace, in this other zone that Minnie calls near space, others have called mesospace or protospace, but I will call it upper or high altitude, let's put it that, high altitude airspace. We need to create some laws to deal with that technology. At the international level, that clearly will require a lot of coordination and a lot of understandings. We need to find the right administrative body, but also, and this is happening, states themselves are also now creating legal frameworks. So as David very kindly mentioned in the introduction, I've had the honor of working with a number of governments in the development of their national space law. And let me just highlight two of them. Australia and New Zealand. I happen to be living here in Sydney at the moment. So in New Zealand, my mandate when I was asked by the government was to help them create their national space law, because they had to react to some space activities that were being developed. And we worked well on that. And then as we continued down that path, the mandate changed. The mandate was, well as looking at what you might think of traditional space activities, There are other activities going on in New Zealand, operated by NASA, operated by some other countries, and New Zealand itself, that dealt exactly with the sorts of things that Minnie is talking about: high altitude platforms, drones, weather balloons and other balloons, pseudo-satellites. And so in their national law, New Zealand said, okay, we will now create, as well as the traditional space law licensing regime that we're all familiar with, we will also create a licensing regime for high altitude platforms. And so when you look at the New Zealand law, which started off being the New Zealand Space Activities Act, it is the New Zealand Space and High Altitude Activities Act. It was the first country in the world to do that. That is a trend that will happen, but it demonstrates that countries have the capability, the willingness and the need to look at this issue. It's not comprehensive, but it's a start, and it does work if you look at that legislation. And the same thing in my country, and then I'll stop, David, because I'm sure we'll have other time for further discussion. In my country, Australia, we've recently amended our law. Our law was traditionally based on space activities. Indeed, not that we designated where space began, but for administrative purposes, our space law applied only if you intended to go above 100 kilometres. Now, with the amendments, the Australian space law also applies to what we call high power rockets. These are rockets that are incapable of going to 100 kilometres. They go above flight, say the flight level 600. They are not aircraft, we understand that, but they do not go into the administrative area that the space law applies to. And yet now that's being covered also with a licensing framework under the Australian law. So what we're beginning to see is states recognising clearly what Minnie says, we need to do something. They are taking matters into their own hands from a licensing perspective. That's not enough, but it's a start. But it also, in my opinion at least, does not require a complete rewriting of the fundamental nature of airspace. Because I think that, in my opinion, and maybe I'm wrong, is a bridge too far for states to accept, at least at this stage. I'm sorry, David, if I've spoken for a bit too long, but thank you for the opportunity. And Minnie, thank you again. And Maria, thank you for your presentation.
Many thanks, Stephen. That was excellent, and provided a very, I think, germane discussion, and start the discussion on where we may be moving. I'm fascinated by your last part about the fact that Australia and New Zealand are now developing national legislation. There's always a yin and a yang about national legislation, given when we're talking about a global commons to some extent, but that is something which we can discuss a little bit later. And one of the questions that came to my mind immediately, given the Maria's presentation, is New Zealand and Australia looking at a spatialist or a functionalist approach to this question? So we can go on to that in later. But so let me introduce the next panelist, who is Stephan Hobe. Stephan is a professor for German public law, European law, and public international law, and is director of the Institute of Air Law, Space Law, and Cyber Law, as well as director at the Law Center of the European Integration Cooperation at the University of Cologne, of course, in Germany. Moreover, he is holder of the Chair for Public International Law, European and International Economic Law, as well as the Jean Monnet Professor for the Law of European Integration. Professor Hobe is pursued his studies of law at the University of Munich, Freiburg, and Göttingen. In 1985, 1986, he studied at McGill University, Montreal, and obtained the degree of LLM. So, Stephan, the floor is yours. Thank you.
Thank you very much, Mr. Chairman, for this extremely kind introduction. Thank you very much to everybody to be invited to this webinar. And in fact, that gives us really unique new opportunities to exchange views. I think the topic is fascinating. Although I need much less time than the person who has spoken before me, because I'm more simplistic in mind. So I will just draw from a paper that I wrote a couple of, 2-3 years ago, that was called The Limits of Space Law, Which Law for Mesospace? So the area in between outer space and airspace I call mesospace for the one reason or the other. Let's think why there is a need for delimitation that gives us all this fruitful thought. There is, on the one hand, as people say, the necessity to apply different law, air law or space law. These are the alternatives. And perhaps we need even a third area of the law for the thing that is in between. Secondly, there are different physical characteristics of airspace and outer space. Already at the beginning of flying, we have this very nice definition of an airplane that needs the air in order to make progress. It cannot fly in outer space. On the opposite side, a satellite has difficulty to go in airspace. So there it seemed to be very simple, that you say, well, there is on the one hand airspace, and there's on the other hand outer space. And it was taken the von Karman line, more or less the lowest perigee of satellite, without that much looking at whether this was really appropriate concerning, asking the question, is really everything below the von Karman line airspace? Let's think it from a different point of view. Yes, of course, airplanes can use, and this has been said in the excellent papers, use airspace only up to an altitude. Well, we fly normally at let's say 30,000 feet. That is 10,000, 12,000 meters, 12 kilometers. Let's say 18 kilometers or 20, 27. These are fighter planes. Also, from the perspective of sovereignty of airspace belonging to the sovereignty of a state, the original idea of sovereignty is that you may defend everything with, let's say, the weaponry or what you have from your place out. That was the original idea of the 3 miles zone, the cannon shot width. I think with all this wisdom, it was never clear to me why one should really make this delimitation between, let's say, at an altitude of, only 100 kilometers, that some countries even wrote in their national legislation for one reason or the other. I think, therefore, that, of course, neither nor. It is, there is really a space in between. There is an airspace filled with air, there's outer space, and there is something in between. We must, however, ask, and I think I very much agree to Stephen Freeland by saying we must ask, cui bono? What is the idea? Is there really a necessity to fill this space, so to speak, this what I call the mesospace? Is it of any relevance? And here, in my opinion, the question of the so-called the approaches for delimitation come into play. Can we and should we stick to the traditional spatialist approach? That's one or the other. So I a little bit disagree to what have been said in one of the papers. The spatialist approach does not really sharply make that delimitation, or shouldn't we look for the very function that an object has whilst flying, whilst being in this area of mesospace, somewhere between 20 or 30 kilometers up to 80 or 90 kilometers. This is, in my opinion, the real point, and the test case comes with applications like suborbital flights, like high altitude platforms, like mega constellations that we will have. Moreover, we will have a problem, and I don't say I have all solutions, with kind of military uses. Let's take drones. Moreover, we must ask the question, who will be responsible for the administration of this mesospace? Is this, so to speak, annexed to airspace and thus being subject to air traffic control, more or less? Or is it some new agency, new authority that we should use? My solution, my preliminary solution, or let's say better that way, my proposal is that in airspace, clearly the sovereignty approach is applied. No problem, aviation law is applied. In outer space, clearly after, beyond the 80 or 100 kilometers, clearly outer space law is applied. And in between, in mesospace, we should apply the functional approach and look into what these specific objects actually do, what they are designed for. And then come to either or solutions that could be either an airplane, that means for us that aviation law will be applicable, or a space plane, that means then that, of course, that means that space law is applicable. I give you just one simple difficulty and then I stop. Questions of liability. Questions of liability for passenger flights to outer space. That does not really exist yet. And if we look into, let's say, suborbital flights, we might have a problem. And therefore we have so far, that those who provide for these things that might never come, but maybe they come, these space touristic flights, that you do it on your own risk. I stop here by saying, in my opinion, a tripartite regime is the regime of the future: airspace, mesospace, outer space, clear application of airspace and outer space law in the extreme regions, and in between, the functionalist approach. Thank you very much indeed for your attention.
Thank you, Stephan, and thank you for raising the liability question, because I think that this is going to be a very interesting part of discussion in the future as Virgin Galactic and others start to send their guinea pigs, their fee-paying customers into space, and if something happens, my goodness, you lawyers will have a field day, I think. So, so let's move on. But okay, I do not believe that Tim Abe is with us today. Unfortunately, is Tim Abe there? I have heard that unfortunately she does not seem to be able to be with us. So we will. I don't see that. So let us move on to Professor Lu Hao. Professor Lu Hao is the director of the Institute of Aviation Law and Standard at Baihang University, and is also the executive director of Global Aviation Development Academy of the Beijing Institute of Technology. Professor Liu has participated in almost every air and space law and regulation drafting committee in China from 2009. He has chaired the legal subcommittee of the ICAO UN USA Space Learning Group. He is the acting chair of the Joint Authorities for Rulemaking on Unmanned Systems, otherwise known as JARUS. He has published in several articles in Near Space and the Exclusive Utilization Space, together with Professor Fabio Tronchetti. Please, Professor Professor Liu, I give you the floor.
Thank you, David. Okay, I think now in the beginning you have mentioned that we have spent 50 years trying to settle the question of delimitation of the space, outer space and airspace. Different countries have a different opinion. So some countries think we need to settle this question. Some countries think, on the contrary, not necessary. But now with the technology development and with more and more high attitude platform, it's saying it's time to settle this question. But why we spend 50 years does not settle the question? Probably we need to think about it. It's time to change the method. So I'm really happy that Minnie and Maria, they have shown some new methodology, trying to resolve the unsettled question in a new way. And that is why we have the draft convention, near space convention. So in this draft convention, the methodology is different from the old convention we are applying now. Well, I think when this is just early stage draft, we needed to work on it, so to make a better version. But when we are working on this draft convention, we should focus on the need of the industry, the customers, the taxpayers, try to make the story, make the new technology, new operation happen. Just try not to be caged by the old questions. So that is that is thinking I have collected based on the presentation and also the history recorded by David, by Jakhu, and by the executive director of IAASS. So we needed to make the story happen. So this is the first point I want to share. And secondly, I think even the convention is quite early stage, but if you look at how many participants we have had today, that means this is a really hot topic. So many people have a strong interest. We have more than, according to my record, we have more than 220 participants today. So I think this topic could and worth a series of a webinar during such a specific season. We cannot meet in person, but we could. But the webinar is reducing the cost of international travel. So I would call for more webinar to discuss this topic. And thirdly, I would like to say the sea is a mother of the air, or is a mother of the space. So when we cannot find a solution just looking into the convention in the air or the space, look into the sea. Probably we could find some inspiration. The Near Space Convention and also the EUS, which is Exclusive Utilization Space regime introduced by Fabio and I, is also a testing of a transplant, the law of a sea into the air or into the space. Fabio and I also prepared some slides, and also the two articles we have published to share with our colleagues. We will share through the Zoom chat function, and we will also send this document to our host, so that you may get the EUS, more information on the EUS. Regarding the comments, detailed comments to the draft convention, I think we may have, if we will have more time, I have a long list of questions and comments for the draft convention, but definitely we will listen to the order of our host. We will listen to the advice of David. Thank you, David.
Thank you very much, yeah, Professor Liu. Yes, we will get into some, hopefully some, I think we have time to get into some details. It's, we have an hour left, so, please continue to provide us, those that are participating through the webinar, please continue to provide us with your questions, and we will hopefully be able to, I'm sure we will be able to take a few of those for the panelists. Last but certainly not least is our host, Professor Jakhu. who is the Associate Professor and Acting Director of the Institute of Air and Space Law at McGill University. Ram has an extremely long history and very, very distinguished history in this topic of space law in general. But what I'll mention, he is currently the project director of the McGill Manual on International Law Applicable to Military Uses of Outer Space, MILAMOS, which is hoped to be published later this year. And Professor Jakhu also served as the first director of the Masters of Space Studies program at the International Space University. And again, these are just a couple of highlights of many highlights of a distinguished career of Professor Jakhu. So Ram, please, you are the last on the panel for this initial go around, so I pass it over to you.
Ram, you needed to unmute your microphone. We cannot hear you.
All right, sorry.
There we go.
Okay, thank you. David, you said long history, that means I'm an old man, not necessarily a wise man. Thank you very much for your kind introduction. Being the last speaker on this particular topic is good, that I don't have to say anything new or anything, and that's also bad. Then what's the point of having a floor if I don't say anything? So I'll try to have something in between. The first thing is I will comment on the previous speakers. As a matter of fact, the panelists. I think my good friend from Down Under set the stage very eloquently. And of course, I cannot, even if I try, I cannot meet his eloquence and his wisdom discussing all those things. But slight difference, and I think among good friends, it's always good to have differences. I think he pointed very correctly, but at the same time, he said this is not possible. Let's look at the politics. Has no meaning on its own. It's based on something. And what is that something? Politics currently, for I will say good reason, is essentially based on economics. If money is to be made, people forget about sovereignty, right? And money is a major factor. The second is the question of safety. If people start dying on the road, you will see fairly strong rules and regulations on the road, right? So to me, economics and safety will dictate the tone, the parameters of politics. And I agree with him, that politics is the one. Politics always wins, by the way. It is the politics that is going to be determining factor on that. So bringing that kind of thing, which my other good friend Stephan Hobe said, I agree with him. You already see, everybody knows aircraft cannot go beyond certain limit, certain height, simply cannot. And spacecraft or satellite cannot come down, like fly around. And that's a reality. That's a necessity that you don't have to be a rocket scientist to understand that. The question is something that in the middle. And Stephan said it, it's a mesospace or near space, so whatever you call it, that is the area which needs some regulation. And that regulation for enhancing economic advantages and ensuring safety. And that is, to me, is important to be kept in understand. Beside that, how you ensure that is a question of licensing. You cannot allow any company or any country to do whatever it's wanting. So you need an issue of licensing control. Who should issue license and under what control, what are the conditions? And more importantly, the technical standards. Whose technical standards are necessary? And if you look at IQ, the raison d'etre of IQ was essentially technical standard. So there's a safety in that way. So to me, all these things need to be worked out. Now, I think we have seen theories and we have seen political debates for 50 years or so, but the time has come to see, hey, the necessity of making money and encouraging private sector and also ensuring safety. There's something needs to be done. In my view, in that way, the draft convention initiated by IAASS is first small, very important step towards that. And I think this is what, of course, it needs to be looked at more carefully later on. So in addition to liability, as Stephan mentioned, I would say the whole idea of licensing authority and also the question of technical standards are critical importance. I stop here. Thank you.
Many thanks, Ram, for those points. Let's go on to a couple of questions that I will ask each of the panelists again to comment on, and I will have my first question will actually have two parts to it, and some of those parts have been already answered. So for example, Stephan answered some of his in his opening remarks, his opinion on the overall idea of a transition region instead of an abrupt borderline between airspace and outer space. Others may want to add some comments on this. So the two parts of the question are, what are your opinions on the overall idea of a transition region between an abrupt borderline between airspace and outer space? And I say several of you have really made that point already, so you don't have to necessarily repeat it. But the second part of the question is, okay, the whole issue of the rights of the underlying state, which has been brought up in the draft convention, and I would like to hear your comments, maybe further comments. Again, some of you have mentioned this. How will that be? How can those be satisfied? Let's put it that way, through either a legal instrument or through conventions or through guidelines or whatever. Where do you think those rights need to start to be considered? And I will also ask, how will that be developed? Do you see this coming through a body like COPIUS? Do you see it coming through a body like ICAO? Do you see it coming through a new body? How could you see this this work in the future? As all of you have agreed that this area is becoming more and more, I say, congested, more and more utilized, with a bunch of questions that in the end will need to be settled at some level. Hopefully it will not take a deadly event to push governments into making this a reality, although clearly unfortunately that might be the situation. So there's a number of questions here I'm asking, and I will go through the panel with the same level, starting with Stephan. So there we go, Stephan. I will ask you to start that.
Thank you, and thank you to all of my fellow panelists for their comments as well. And it's nice that we don't agree 100%. Let me just make it clear, where we are in absolute violent agreement is the need for regulation. The question is whether we need to create a whole new area to meet that regulatory requirement. At least at this point, and of course I remain to be convinced, my own view is that there's a lot of hard work that needs to be done on the regulatory side, but it doesn't necessarily require the creation of a new area. But I've made that point already. In terms of the underlying rights, of course, we can go through the detail in the draft convention, but what we are actually doing here is taking away rights from the underlying state from where they are at the moment. Now, that is maybe intended. People talk about safety and liability, all important, all important. However, you know, so I agree with that, but we are actually taking notions of sovereign rights away from underlying states by saying all of a sudden that at some point, and I know that Minnie made it clear that the points were up for discussion, but at, you know, flight level 600, 18 kilometers or whatever it is, up to 160, all of a sudden we are saying, well, at least at that lower end, we are saying that this is different to the sovereign rights that the underlying state presently has. As I said in my opening remarks, the underlying states clearly recognize they have jurisdiction, and they have jurisdiction to go into this high altitude, and they are beginning to exercise that jurisdiction to reflect the technology. So, of course, the drafters of the convention have whilst they've changed the nature of the sovereign rights, have purported to say that there's an exclusive use there. But that's different. And Ram says, well, it's not about the politics, it's about other issues. That may well be the case. I hope it is the case. I hope I'm wrong. But the reason we don't have a demarcation between airspace and outer space is purely politics. Purely politics. No matter what technological advances we've made in the past, since the day I was born, Stephan and I are both Sputnik babies. So from the year we were born, technology has raced forward, and yet politics, by and large, has intervened. Space is regarded very sensitively in terms of national security. Both Ram and I and Stephan are working on a project to lower the rhetoric about military uses and national security, of course, but the fact remains that states are very insecure about their national security. And so if you change now the rules, albeit for the right reasons, but if you change the rules that somehow give lesser rights to the underlying state over what is a strategic area for them, and perhaps a greater possibility, I recognize that there are exemptions and you need permission, but a greater possibility of others doing things over their territory, then you will also raise that spectre of national security interest, rightly or wrongly. I mean, I'm not taking a side here. I'm just saying that we have to understand, there has to be a sort of a reality check here, that we are, as to what we are attempting to do, albeit for all of the right reasons. In terms of the responsible body, that's an excellent question, David. There has, as we're all aware, been discussions from ICAO has looked at this increasingly so in the past few years. Perhaps 10 years ago, it was not really an issue that ICAO looked at seriously. Since then, they have. And the space community, perhaps led by the United Nations Office for Outer Space Affairs and just some discussions on the delimitation issue in COPOS, have increasingly looked at this issue. Whatever we do in this area, we need, as I said, to think very carefully about the regulations, and we need to have expertise to manage the regulations, and we need to have a body that takes responsibility for managing, because as everybody has said, there are real safety issues involved, not only in that area, but on the ground and to spacecraft going through this area. So these are very complex issues. We're all agreed that work has to be done. All I'm saying is that we don't necessarily have to change everything, because technology will change and change again. Recognize that we've changed maritime boundaries in the past. And if you start creating one boundary and then, you know, in 20 years' time, because the technology has changed, we then start arguing about changing boundaries again. That gives rise to uncertainties, not to the clarity that we all need. We need the clarity in the regulations, but I'm not convinced yet that we need to actually create this middle area, although people who are far wiser than I disagree, and that is fine. But I think we're all on the same side in terms of the need to coordinate and have proper regulation to ensure that questions of liability, safety, interoperability, accountability, and it's traffic management and all of those issues are met. But I think they can be met, albeit with difficult discussions, through the system that we have already. Thank you.
Thank you, Stephen. As a moderator, I'm going to ask one question as a non-lawyer. You mentioned that one of the issues that you're concerned about is limiting the jurisdiction of a particular state by starting to define where these intermediate boundaries might be. But currently, as far as I understand, unless it's understood in customary law, a state could effectively say that their airspace, their jurisdiction, since there's no definition, could be at 200, 250 kilometers. Is that correct? And therefore there is, therefore they believe that space starts wherever. And they have the right to control that area or have the jurisdiction of the area because there's no agreement. So what is the legal, how does customary law define and deal with that question?
Well, that's an excellent question, David. States can say whatever they want. The mere fact that a state will assert something doesn't mean it's the law. We know that as a fact. We know there's no demarcation. We know that some states have in the past asserted that the area on geostationary orbit at 36,000 kilometers above them is part of their sovereign territory. And indeed, if I'm not mistaken, that is still part of the Colombian Constitution. I think Article 1 of the Colombian Constitution. However, it's widely recognized that that is not the correct legal position. And it's widely recognized that we know what space is when we see it. Of course, as lawyers, we would all love to have a demarcation because it makes logical sense. It makes logical sense to know when one regime of air law ends in terms of its applicability and another begins, albeit there are questions about what law applies to something that traverses both. But that's a separate question. We all want this demarcation, but we haven't got it. But we know what space looks like. We know, and it's widely recognized, for example, that when something is in orbit, then nobody questions that that's in space. When we talk about suborbital, of course, it becomes a bit grey, and we are now having definitions. And of course, that's part of the work that needs to be done. But I'm not concerned about a state now asserting something that is 500 kilometers as part of their sovereignty because it's widely recognized that that has no legal foundation. So I don't think that really is a problem. I think the issue is more trying to get an understanding about what we need to do in areas that traditionally haven't had a lot of regulation, but now technology requires. Thanks, David.
Okay, I thank you for that clarification. That was very, very important. So I will now pass over to Stephan. And again, the question is the transition region as an abrupt border, which I think you have already noted, but if you want to just note that, maybe note that again, and your thoughts on the proposed rights of underlying states. And my other point of this question, a multi-pointed question, is do you have any ideas of what body might want to take this up in response to the issues that we're talking? What intergovernmental body might wish to start to take this under their agenda in a way that might be a refreshing new approach? Let's put it that way.
Thanks very much, David, for this this very stimulating new round of questions. Let me start by saying one thing. The very fact that a state could claim as its airspace all the zones up to 80 or 90 kilometers is not so sure. It has never been written anywhere. The UN Corpus has, since its first session, we have repeatedly said this today, said there needs to be a demarcation between airspace and outer space. So, me as an international lawyer, I can draw from this only the conclusion there was bluntly unclarity about this demarcation line. Now we have a need, and I think my good friend Ram has made very important points. We need to address the region between 20 and 80 kilometers as a matter of safety and as a matter of licensing. So we need something that does traffic management. That's, first of all, a subject of, for any airplane, including there is a national task. And we are considering this of becoming important and necessary for outer space as well. Because if there is more commercial users, we must avoid collisions at any instance. It's absolutely crucial, because otherwise we'll have everything full of space debris. So we need to do that. So what I foresee in the future, if there is more commercial users of outer space, we need really strict traffic rules. And then, of course, the question will be overall crucial to have a regulating body. But the question, unfortunately, is not so simple. Though we could now ask, and normally the question is asked, should it then be UN COPUS, should it be the United Nations, or should it be the Specialist Agency for Aviation that has also some expertise? The real crucial point is that, of course, there are also military considerations. And of course, this space between 20 and 80 kilometers is also of military interest. And particularly our Chinese friend, whom I know very well, Yohao, remind of the question, and I'm absolutely convinced that China will insist on having this, and that makes this problem so intricate and so extremely difficult, so that I don't dare at the moment to give any answer. I could theoretically think of ICAO, which has the expertise. But apparently it is interesting that, for example, the Chicago Convention, and with this the application and the task of ICAO has nothing to do with military flights. It is sometimes customarily applied, but in principle, if you see, no state aircraft is regulated by the Chicago Convention. So perhaps for these regions, if we come at all at any kind of conclusion and kind of common sense, something new should be instrumented, or one should actually give ICAO or another agency kind of more power, regulatory power that, for example, ITU uses also for the kind of regulation of uses of satellites in various orbits in order to avoid interference, which is exactly what we want to achieve. But at the moment, I need another doctoral student who writes another doctorate dissertation on that topic before I'm able to answer. Thank you very much.
Thank you, Stephan. Excellent. I also note that, of course, COPUS, or the Office for Outer Space Affairs, does not also deal with military or defensive systems either. So we are, the systems which don't even have to be registered under the convention. So there are some very interesting issues with respect to all that, of course. And as far as the ITU is concerned, one positive point about the ITU is that it does allow discussion, at least with the private sector. And that is something which we'll get to in my next question, but because this is going to be, I think, part of the driving process as we move forward. So Professor Liu, please, over to you on this topic. There's been some interesting discussions so far.
Okay, thank you, David. For the first question, I think we do have some purely aviation activities, we do have a purely outer space activity. For those, we have a convention already, the Chicago Convention, and also the Serious Space Convention. And the topic we are discussing, the near space, the draft convention, is trying to reserve the activities that may happen between 20 to 100 or whatever. It may even start from 18 to 160 kilometers. It will be decided later. So for those activities like the suborbital, we cannot get these activities to be well reserved by this draft convention, because the characteristics, the legal regime for the suborbital, it's another topic. Probably we need to discuss later. Well, regarding the undernight countries' rights, I think first, the undernight country has the freedom to declare the near space, the attitude, and also have the right of regulation. The third one will be the priority to utilize the near space. In our solution, Fabio and I would like call it EUS. So the EUS will give the undernight country priority for the exploration of the near space. And the fourth right will be the power of regulation, the activities, no matter it is operator registered in this country or the foreign operators may have their operation in the near space, which is above their territory airspace. So that is our recommendation for the rights of the undernight country. You may find a rows of points in the slides. And for the body, which one will be the best or the platform to make a new convention or discuss all these topics? I think not just one. We have UNCOPIAS, we have ICAO, we have ITU, but all of these three platforms are just regulating one specific area of this topic. We need this international organization to work together, and it's happening. At least now ICAO and UNCOPIAS is setting up a space learning group. We do have people from both aviation and space are working together on this topic. I hope this may continue, and this may get more experts to work on this topic. On the screen, I see the face of Christopher, who is from ICAO office. I also found the name Sue, who is the chairperson of ICAO legal committee. While on the screen, I see more faces from the space world. So today, such a webinar is also good non-governmental platform to let the experts to work on the same topic, to give advice to the UN special agencies or the UN bodies. So not just one platform, let rows of organization to work together. Thank you, David.
Thank you very much, Professor Liu. And yes, and I very much appreciate you mentioning again the fact that this learning group of ICAO and UNUSA has been generated, and that of course you are very heavily involved in it. And we wish this group good discussions in the future, and hopefully this this webinar might stimulate a few ideas, and that's why we're all meeting together. I also should mention to the attendees that Professor Liu has published on the chat, so go please to the chat, and for everybody to see the references to the papers that and the presentations that he and Professor Tronchetti have on this subject. They should be anybody that's interested in this subject should be downloading those and looking at them. They're an important contribution, so thank you. Lastly, in this round, I will pass to my good friend Ram and for the comments on these couple of questions.
All right, thank you, David. Very, very interesting discussion, I must say that. Thank you all the panelists. I have two points to make. Just first to answer your question, David, about the rights of underlying state. And I think, to me, paramount importance to all states is safety and security. And that has all been recognized by nations all over, irrespective of the international treaties they sign it. They always reserve that kind of right. Even look at Chicago Convention and other areas that the states have the right of closing their airspace. You know, and that is, I think, it should be considered in any new instrument or the old instrument, legal instrument which is adopted, safety and security of the nation. Secondly, I think we should always recognize, I kind of reiterate my point, the law is not made for the sake of law. What did you say? Necessity fait loi. What is the necessity here? The necessity to be recognized, the technology is developing, companies are becoming very impatient with the current situation. Things have to move forward, and they are moving forward. The law will lag behind, and then will be chaotic situation. So that is what is coming. So I reiterate, by the way, just on the learners group, if I'm allowed to say, is that the whole idea was discussed at the conference with the Institute of Air and Space Law, organized with the help of IAAS as well as ICAO back about 6-7 years ago. And then, of course, the learners group grew that. I think learner group initiated very good ideas and discussions in that way, and I think that kind of discussion is necessary. My last point is, I think, is a very, let me reiterate what Tommaso Scoba, Paul Dempsey, and I put together in the form of a book, Integrated System. To me, I can make a perfect case for ICAO to be involved in this one. ICAO in association with other institutions, ICAO taking the lead. The reason I'm saying is because ICAO has no choice, and I see it intentionally. ICAO has no choice but to get involved in this area, simply because safety of aviation. There is no need for ICAO if it doesn't look at the safety of aviation, right? And that is what is very important. The former president of ICAO Council and other people like the Sanat Kaul here from India, these are the people who have been talking about it is necessary. Now, I don't think there's a need to amend Chicago Convention. ICAO Council can take the decision, can adopt annexes. And ICAO has been following, at least in my view, ICAO has been following what is you call it in legal theory is the theory of implied powers. ICAO has been quietly expanding its jurisdiction on the areas over the factors which are not in Chicago Convention. You know, number of things. So it is a necessary for ICAO to get involved there. And also you see at national level, you go to FAA, for example, dealing with aviation and also getting in space. So air and space are not totally, you know, they may be today seen separately, but they're going to merge together. And I don't think to do that, you need, and luckily or fortunately, both the conventions, Chicago Convention and Outer Space Treaty, have no really restrictions, prohibitions, or controls or barriers for coming up a unified regulations or laws in that way. So you can look at some ideas, pick up some ideas from Chicago Convention, some ideas from outer space, and develop that kind of thing. It's not easy. I'm not saying it's easy. It's difficult. But the question is, it needs to be looked at from that angle. So my point is, ICAO is the body which has to look at that very carefully, and it will start looking at carefully. And I dare to say that the United States say, yes, we have to go for that. Right? Because it's going to be in the interest of the United States. Take the example of suborbital flights. Suborbital flights, if they have to be expanded, they will not be going from New York to Chicago only. To make money, the companies had to go from New York to Vancouver or to Tokyo. Whatever happened. How well US will do? Okay, you can do it bilaterally, no doubt about it. at the same time, you need a multilateral efforts to get into that business. Who can do that? I think IQ. IQ is already well-established institution. I think it, to me, working pretty good, but that is what it needs to do. So I think, to me, the rights of the underlying states need to be looked at, and they will be done. Secondly, IQ is the body which should look at the technical standard, safety of all these things. You know, there I stop.
Thank you, Ram. This leads me to my last question of this round, and we may have time, hopefully, to ask a few questions from the audience, from the attendees. But I'm going to concentrate this time on the commercial space. You led very well into this, Ram. The fact that that the conventions that have been developed by ICAO really were the spur to promote what we now know today. Well, actually not today, we're in a pandemic, but that we see as the development of a private sector, a commercial sector, which has been extremely successful. And we can envision, and many panelists have talked about this, we can envision a similar type of push in the next 10, 20 years. And I think that if none of us can look in the magic mirror and see what's going to happen in 20 years, but I think that we can probably expect to have a lot of point-to-point, as you say, flights through this protozone, as you mentioned, Ram, and a very, I would say, a burgeoning commercial sector dealing with this area. So my question to you is, does this convention, as it sits, satisfy what we are likely to see in the next 10 to 20 years, when really, besides the military applications and besides governmental applications, we will really be looking at an explosion, one might say, a potential explosion in commercial utilization of this region. So I will ask the same panelists that question, and I will start with Stephan.
Thanks, David. It's always dangerous to use the word explosion when we're talking about anything to do with space. So, so wash that word from your mouth. Look, there's absolutely no doubt that the development of technology will give rise to many, many commercial possibilities that we can't even comprehend at this stage. Already, this area, whatever we call it, so I will call it the high altitude area, already this high altitude area is being used for commercial purposes. Albeit in a relatively embryonic way, but large companies, Google, Google Loon is doing it. NASA is working with other companies. Ground-based telecoms are working with other companies in this high altitude space. And no, I'm sure there are many. So it's already happening. It's already happening. They are in an area where they will be and are regulated by their national jurisdiction. Now, I'm not saying anything's perfect, but there already is a licensing regime in place, albeit it needs to be beefed up. There already is. I mean, if you look at the legislation that I referred you to at the beginning, I'm just looking at it now, the type of information that in New Zealand, someone applying for a license has to give before the minister will even consider a license is enormous. You know, it has to talk about frequencies, location, purpose, duration, altitudes, plus a whole range of other things. So the point is, already commercial people want to engage, already governments have to react. But it's not enough. We all recognize that, albeit I think that governments will have to take a lead and regulate those who want to engage in this, but it doesn't meet and it won't meet the necessity for, let's say, commercial suborbital flights, which everybody on the panel has talked about. Clearly, we're all excited by that idea. And no, because we're talking about point to point, we're talking about cross-jurisdictional, clearly national law is insufficient to deal with that. And clearly, as everybody has said, the existing regime doesn't help us very much at all when it comes to regulating that. So we will need, as I said in my opening remarks, a mixture. We will certainly need countries to step up and ensure and regulate those that want to engage, not just in space, but in this high altitude. But in addition to that, we will need to find, as everybody has said, international standards, international agreements about a whole range of issues that then everybody will need to implement back into their national frameworks. We do that, that's a similar process to what we used to, albeit now we're talking about something different. But clearly, the commercial sector will push for the ability to utilize this. I don't think the commercial sector is going to be the actual determinant about some of these decisions, but it's certainly a relevant factor, and there's certainly a lot of work to be done, but it's already started. Thank you.
Thank you very much. I'll pass quickly over to Stephan.
Thanks very much, David. My answer is relatively short. Any kind of legislation that requires proper licensing and proper safety standards, so an overall traffic management, will serve the purpose and will serve commercial purposes. What I foresee, but this has just a little bit to do with our today's topic, is that space transportation will be the thing of the coming time. Not so much tourism. It will be space transportation. And if that is so, we need clear rules. And in that perspective, our mesospace or neospace, or how you call it, may play a role, and we must look and take an all-encompassing approach. So on that, maybe we need something what some early drafters talked about as an aerospace convention, that we do something really together, that we have common organs to administer this for the sake of safety and perhaps security. But my major point is, and I have no solution for that, but then I stop, that is the military use, because that is, of course, something the militaries don't want to be that open. They want to be, it's a national thing, it's a domestic thing. They want to cover up for security reasons, and I don't deny those security reasons. This, to harmonize, will be the crucial question of the future, as I see it. Thank you.
Thank you very much, Stephan. Professor Liu.
Okay, thank you, David. I think now the technology we are using in the near space, even in the suborbital, quite a lot originated from the military side. So we do have concern from the military, and we have to pay attention to their concern. Stephan mentioned the Chicago Convention. Chicago Convention is for the civil aviation, but the Chicago Convention does provide the rules for the state aircraft. So if you check the Chicago Convention, we do have several articles are citing rules for the state aircraft and their activities. So we will not, the new convention, I think, will not targeting the military activities, but we may set several rules which are acceptable to the military. At least they will not endanger the activities in the near space or the commercial suborbital flight. So that is for the military concern and how we may balance the interest between the commercial and the military. Well, for the regulation of the undernice country, I would like encourage the undernice country just focusing on first the safety of the operation. This will be a quite safety operation convention. Secondly, how to establish the international regulation regime for the commercial or civil activities, so that the operator has a clear understanding of the economic regulation. Because in the airspace and the telecommunication, we may agree that no regulation, no business. So we needed to have a regulation to facilitate the international operation. Okay, thank you, David.
Thank you very much. Ram, please.
Thank you, David. I don't have much to add to what already has been said by my good friends, except that I just want to remind the audience that our first director, John Cobb Cooper, before he established the Institute of Air and Space Law at McGill in 1951, he was of the opinion to have aerospace law. And I think we are coming to that point, and Stephan has made a very good point. We are talking about not air transportation or space transportation. We are going to be talking about aerospace transportation. And that also is the issue of have integrated rules and regulations. And now we means international community may be a little bit reluctant to take that giant leap up front, but that's what is going to happen in that way. So again, my view is that IQ can take that leap, and it should take the leap in that direction, because the technology is that we are talking about suborbital flights or orbital flights, but they will also be, not taking passengers from Montreal to Tokyo, but they may be going to International Space Station, maybe having, somebody going from Montreal to International Space Station or Google Space Station and have a lunch there and go to have a dinner in Tokyo. And the whole purpose, the whole thinking of orbital flights and transportation, I think is going to be a matter of past. Nobody can development of technology, especially when it is useful. So I think the law has to keep that. Now, I am not saying there has to be a convention or treaty on aerospace law today, but I think a step towards that is necessary in that. Thank you very much.
Thank you, Ram. I'm going to ask both Maria and Minnie to step in here and make some comments, final comments, if they would like, on what they've heard, and with respect to their thoughts, because they have done a lot of work on their discussion papers developing some of these ideas. So there's been a lot of discussion here, and both positive, I would say, and well, no, they're all positive points, but I mean, say some supporting strongly the convention, others having, well, everybody questioning certain aspects of it. So let me pass over to Maria. Do you have some thoughts on what you've heard?
Yeah, I'll have to keep my video closed because I'm having some connection issues. But yeah, it's definitely a challenging issue. The challenges are many: safety, legal challenges, technical challenges, and it's an issue that's been long discussed. Now, I'm not part of this draft convention. I've just done some background research on the issue, and I do see the draft convention as a potential way forward. I don't want to say this is the way to go forward, or that the states should not agree on this convention, but definitely the new technological developments call for new laws, and we've seen that vehicles are creating new spaces compared to the traditional spaces of airspace and outer space as we've known them through traditional air and space activities. So perhaps it is the right time now to test the reaction of states, whether they have a positive or a negative reaction, through perhaps one more working group in UN COPUOS, or a joint group through UN COPUOS and ICAO like the previous one, focusing specifically on this zone. We might want to call it protozone or mesozone or near space. But I do see the challenges, and I do think that right now is the right moment to not accept the solution, but discuss the solution at the very least. Thank you.
Thank you, Maria. I appreciate that. Minnie, any thoughts on your side?
Thank you, David. Lots of different perspectives have been given, and I actually like what Professor Stephen Freeland said, that even though our perspectives are different, it's just the focus that we have, that this is an activity that needs regulation. That is something we all agree on. And that's a good starting point to build a consensus on. And I do think that what Professor Howley was saying, that there are different platforms that we should think about, like ITU, ICAO, UN Corpus. All platforms are equally important right now, like if it's a new idea that is being proposed. And I think a fresh approach and taking into consideration political and economic will of states would be a good idea, like not just thinking of the draft convention in terms of an international treaty to create a new space, but also convincing countries to come up with national legislations and probably have some kind of state practice developed that can later lead to an international convention or international agreement on this area. That could be helpful. Thank you.
Thank you very much, Minnie. I'm going to ask each panelist now to give their final thoughts, and I'm going to ask them one extra question. Clearly, if we are to move forward, this is going to have to be driven by states. They can be pressured and pushed by the commercial sector. But every ITU, ICAO, UNUSA, COPIUS, they respond to states. So my question to you and for your final comments is, do you see, and each of our panelists has a lot of, I would say, contacts within the international community. Are there any nations or states that you see that you think could start to take the lead on developing a new consensus for this question? We need new thoughts, we need new ideas. Not necessarily this convention, but a new approach to this whole question in order to move forward. So Stephen has already mentioned the work being done by Australia and New Zealand, but is this, would those states be willing, do you think, to move this into the next phase of multilateral discussions in order to develop something which could be long-lasting? Because all of you have mentioned the need for a legal framework here. So I'll start with Stephen.
Thank you. And I said to David at the beginning, I turn into a pumpkin after 2 o'clock, and so in the morning, and so if I look very pumpkin-like, apologies. Given this is the last time I'm going to be speaking in this panel, I think we're winding up. Let me first say thank you again to the organisers. I'm really grateful, and thank you to everybody, all the panellists, and also Minnie and Maria and you, David, for just a wonderful discussion. So I feel like I'm a slight outlier in this discussion, but that's good. I think it's nice to have a refreshing thing. Okay, so is there an appetite for this? Well, there's clearly an appetite and a recognition that something needs to be done. Other states, I mean, I've been contacted myself by many people, many delegations about the work done to create licensing for high altitude platforms. So many countries are interested in the idea for their own perspectives. So I think, and that's driven by their own perceptions of their national security, perhaps their own commercial interests, etc. On the military side, I also recognise that this draft convention only talks about civil and commercial and was not intended to cover military. And military, as Stephan mentioned, is a whole other issue that we need to think about. So I think countries will drive themselves to a certain degree based on their own perceptions of their own interests to look at this. But I think there's more than that. I think there needs to be a push, and civil society can do that as well, but there needs to be a push through certain countries for a broader discussion on the move towards an aerospace law. I think we're all agreed that we need to have particular international regulation as well, augmenting and complementing the national laws on specific areas that really aren't covered very well in the existing regime. Will that be championed by a number of countries? I'm not sure. There are so many other issues, both at the space level, but also at the air level, that are diverting a lot of energy of countries, on other areas. You mentioned that I have the privilege of hosting discussions on resources. That's taking a lot of discussion in the space arena. Not the only thing. Space debris is taking a lot of discussions and other issues. So to add another thing and have a champion and then have meaningful discussions is not easy, but I think there's a necessity. I think certain countries probably are in a better position to do that and probably have more motivation to do that. I have no doubt that we will be having discussions in more detail on the regulation of this area, both at the national level and at the international level in the future. But I'm not sure whether that will be tomorrow, because like it or not, there are just other priorities that at the moment, for whatever reason, are taking the focus. And we know the way that these international institutions work. They're not very good at looking at 4 or 5 different hydra that are rising at the same time. They look at issues at a time. So I think the momentum will be driven at the national level, but there's certainly a need for broader discussions. And I think platforms like this webinar are the perfect way. I hope we've had delegations attending. This is the perfect way to get that idea out there of the need to do that as sooner rather than later. Thank you again, everybody, for your attention to me, and I apologize if I'm slurring my words at 2:26 in the morning. Thank you.
Thank you, Stephen, and thank you for staying up with us this late. And by the way, for a pumpkin, you look very splendid indeed. So thank you. Stephan, please.
Yes, thank you very much. I do the same way by first thanking you very much for the wonderful presentations by Mini and Maria. Then also applauding to this very able chairmanship of David. Thank you very much for that. And of my very nice fellow panelists. I say this because my conclusion is rather skeptical and rather pessimist. If I look in today's international spheres, and this is particularly true for aviation and space, I see anything but consensus. If we look into the United States, the Soviet Union, or what is today Russia, China, and other great powers, who had to bring up such a thing, I don't see any possibility of consensus as concerns space debris, which is a pressing point for us, or let's say exploitation of resources in outer space. I don't see any kind of consensus, but kind of dissent. Moreover, as we have several times mentioned, there is a military overtone, and you may like it or not. It has to do with that, and it must be reconciled, these interests. Otherwise, the thing will not work. Perhaps in the future, we might get some point. I normally would say, well, yes, Europe could start to jump in, maybe associated with Canada. We are old allies, having some kind of environmental, peaceful ideas, but I'm not even so trustworthy as the European Union is concerned. It's also, this is the next pity, but I don't want to scratch out all these difficult situations. My bottom line is it doesn't look like at the moment, at least from my eyes, it doesn't look like that countries are looking for consensus, even with regard to these very important questions, except that at one point the time comes where economic interest is greater and drives countries to come to a consensus. But so far, even with the mitigation, remediation of space debris, it hasn't been big enough to come to some action. Thanks very much, and I apologize for my very pessimistic last word. Thank you.
Not at all, Stephan. I think it's a very important point. So thank you very much for your contribution, and I'll pass now over to Professor Liu.
Okay, thank you, David. My dear colleagues, first I would like to express my sincere thanks for your participation, for your time, for your contribution. Well, regarding the question from David, I would like to share the situation now in China. We reported the situation on the suborbital, on the near space to both our Civil Aviation Authority and the Space Agency. All of them have a strong interest. We are conducting some research, gave consultation to them. So at least I can see that China will be very happy to join the international discussion to provide our understanding of this topic. Well, how to make seek for the international consensus or make this the program move forward? I think we need a more non-governmental, non-official dialogue, like the webinar we are conducting right now. Because if we put this topic into UN COPIASS or into the working paper in the ICAO, then all of our colleagues, especially those of colleagues working in the government, will be more conservative. So we need to establish a channel to let those people who are representing the country in the UN system to be well clear what is now happening and what kind of consensus has been reached by the academic world, by the experts. Well, keep this topic in the agenda of UN COPIASS, ITU, and ICAO. So, but it needs more time, like 5 or 10 years, to make some real official document to be well drafted, written, or accepted, put into force. But at the beginning, we need non-official, more flexible dialogue. Thank you, David.
Thank you very much. You make a very strong point here. Yes, more discussion is necessary, and I appreciate you saying that the webinar has been useful, and I think it has been. Also very positive that China is considering stepping up, let's say, potentially, and bringing this forward, which would be, I think, a very positive step. So thank you. I'm going to wrap up now. Leave the last word to my good friend Ram. We're over time. I apologize for that, for those who are still with us. This has been to me a really invigorating and excellent series of discussions. And of course, thank you really to the people who have made it possible, Maria and Minnie, for their excellent work on the papers, to the invited panelists, and being so open, so free with their time, and also with their ideas. And I think I have gained a lot, and I hope other people have gained a lot. Also, please thank you to Kieran, who has been working heavily in the background. I'm sorry we didn't get to any of your questions, but again, just to repeat, everybody who registered will be receiving a Google form. Please fill that form out, and if you had a question, and please make sure it's recorded and sent back in again. All these points and comments and will be considered by the International Association for the Advancement of Space Studies, and will help to develop the next draft of some ideas here of a convention. So please do not, please make sure you do fill that in. Apologies for not having any time in these past couple of hours to get your questions. And again, thank you, Stephen. Thank you, Stephan. Thank you, Howe, Professor Liu, for your extremely I think frank and an honest discussion of this, and I hope that, and I believe that we have made some significant I would say interventions here that can help this process. So Ram, you have the last word as always.
Thank you very much, David. That's a big responsibility to have the last word, and I do not really know how I can perform that responsibility in that way. I must say, I am born optimist, and I am an academic person, and I think humans, and we are, our humanity, is capable of doing terrible things, but we have also the instinct of surviving. And I share the pessimism, which I don't call actually pessimism, which my very good friend, both Stephen and Stephan said it to me, that it's a realism. That's a reality. But the reality has to be seen, in my view, in the context of the time we have, the humanity has it. So I will go with what the Hobe said, 10 years. Now, I do not want to forecast or predict. My view is within 10 years, you will see some regulation in this area, because we have no choice. Humanity or governments or private sector have no choice, or the international organization have choice, but to come up with that, simply because the technology cannot be stopped with respect to going into space for space transportation system. So that is my, you can say, it may be wishful thinking. I do admit that. But again, I think that's what it is going to. I think the dialogue which we have, it has been wonderful. Now, one point there, who should take the lead? My view is that if we look at the history, those who are, capable, look at the future, powerful, they're always the one, the leader. And I look at particularly the United States, and of course China, and I will not say Russia and Europe are behind. I'm talking even 10, 12 years. I think this is going. I see it's not said very, quite often. My view is the US is on that path, bringing air and space together, domestically first, and then bringing its model to international community. I think that's where you will see that kind of things happening. That's why you see that. So I am optimist. My last word, if you say that, I will say thank you, thank you, thank you. Maria and Minnie have done a wonderful job, and of course, all other panelists. And I appreciate the patience and obviously interest of all the participants from different parts of the world which joined us. It has given us a lot of ideas. I mentioned to you, McGill University has no say, has no input into the draft, but we have been invited, so we took advantage or ventured out seeking the views, wisdom from all of you or commentators or panelists. So we will participating in revising this draft convention with IAASS and presenting to copyists next year. Now, one person we have not recognized, and I want to say that is another David. David Chen, is my colleague who is executive director of the Institute of Air and Space Law. He has been doing a fantastic job with the Kiran. Again, thank you very much. And be safe. Thank you very much. We are looking forward to your comments. And if you have difficulty finding Google or all these technology, just send me an email. And we will appreciate. Thank you. David, the last word I want to give, you have done a wonderful job. Thank you. It's my privilege to be your friend, and I think you consider me your friend. Thank you very much, David. I'm talking with David Kendall. Thank you again. Have a nice time.